Hey there, this is Eric Etstepenis, General Counsel for the Massachusetts Chiefs of Police Association. This roll call video is meant to provide a brief overview of a recent federal court decision which ruled on the constitutionality of General Laws Chapter 272, Section 99, the wiretap statute, as applied to secretly audio recording police. So, on December 10th of 2018, the United States District Court for the District of Massachusetts ruled on the constitutionality of Chapter 272, Section 99, as it is applied to government officials performing their duties in public in the matter of Martin versus Gross and Project Veritas Action Fund versus Conley. But first, let's take a second to review the elements for a charge under Chapter 272, Section 99. This charge may be appropriate where, although not authorized, a suspect willingly committed an interception or attempted to commit an interception or had another person do this of any wire or oral communication. So let's look at what the ultimate ruling of the court was in this matter. The opinion states that the court holds that secret audio recording of government officials, including law enforcement officials, performing their duties in public is protected by the First Amendment, subject only to reasonable time, place, and manner restrictions. While I'm sure many of you are shocked by this ruling, it's really not all that surprising based upon the court's analysis. So let's take a quick look at that. So while the court goes into a lengthy First Amendment analysis, which I'll spare you the details of here, there are a couple of things that police officers may want to note. First off, the court cited to two prior First Circuit cases in support of its holding. Specifically, it cited to Glick versus Cuniff for the proposition that a citizen's right to film government officials, including law enforcement officers, in the discharge of their duties in a public space is a basic, vital, and well-established liberty safeguarded by the First Amendment. Many officers will recall that this case was a shot across the bow, warning officers that they must not arrest people for wiretap violations simply for openly audio or video recording them in the performance of their duties in public. The court also pointed to Jarrick versus Beggin, where the First Circuit ruled that the First Amendment right to film police carrying out their duties in public, including a traffic stop, remains unfettered if no reasonable restriction is imposed or in place. Okay, I know what you're thinking. Seriously, Eric, an outhouse? Is that really the picture that you put up on the screen? Well, yeah, because the next thing the court considered was the purpose behind Section 99. And what is the purpose of Section 99 above all? Well, to protect privacy interests, right? So the defendants in this matter actually asserted that the purpose was to ensure that all citizens, government officials and private citizens alike, receive guaranteed notice of being recorded so that one could respond appropriately. While the protection of individual privacy is a legitimate and significant government interest, the court determined that government officials have diminished privacy rights when performing their duties in public. The court again cited to the Glick case in support of this. But I know some of you are wondering, what about Commonwealth versus Hyde, the Massachusetts SJC case from back in 2001? Officers may recall that in the Hyde case, the SJC relied on a plain language of 272 Section 99, which specifically prohibits secret recordings. The court stated that the statute was unambiguous and has no exception allowing private individuals to secretly record public officials, even police officers. This may be true. However, the Hyde case did not consider the constitutionality of Section 99 under the First Amendment, as the court did in this particular matter. So what are the recommendations as a result of this case? First off, we're kind of waiting to see what happens with this case, whether an appeal is going to be filed, and if it is filed, what the First Circuit does in this matter. However, for the time being, officers should consider the following. First up, officers should not utilize 272.99 to charge those who either openly or secretly record police officers performing their duties in public. Additionally, officers may utilize 272.99 to charge those who secretly record police officers performing their duties in non-public places. So for instance, maybe an individual walks into the police department and comes into the lobby. In the lobby, that could be considered to be a public place. But once past the lobby, maybe into one of the offices within the police department, they're likely no longer in a public environment. Furthermore, officers may utilize 272.99 to charge those who secretly record police officers not performing their duties, whether in public or in private. Officers may still take reasonable steps to maintain safety and control, secure scenes, and protect the integrity and confidentiality of investigations. And lastly, officers may take action when a person is violating other statutes, independent of the fact that they are recording. Now, like most of the recommendations that we make, these recommendations too are premised upon the principles of Section 1983 liability. So, as a reminder, we know that 42 U.S.C. Section 1983 provides that every person who, under color of law, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable. As a result, there are three elements for a basic Section 1983 claim. A person must be deprived of a civil right. So for instance, rights under their First Amendment, Fourth Amendment, Fifth Amendment, something to that effect, by somebody acting under color of law. However, officers many times seek refuge from such claims by filing a defense, claiming they're entitled to qualified immunity. Officers must remember that a police officer is protected from liability under Section 1983 unless the officer violated a clearly established right at the time of the conduct. A right is not clearly established unless the right's contours were sufficiently definite that any reasonable official would have understood that he or she was violating it. Essentially, what the Supreme Court has said is that qualified immunity is meant to protect all but the plainly incompetent or those who knowingly violate the law. As a result of this ruling, it can be said that this case clearly establishes the law that despite the provisions of 272.99, officers cannot arrest an individual for secretly recording a government official performing their duties in public. So as a result, officers should consider the recommendations previously discussed. Likewise, departments should consider updating any applicable policies, ensuring employees are being supervised in accordance with those policies, and then conducting training to ensure that employees are trained on any updates to those policies. And if I may conclude with a quote, "Do not let what you cannot do interfere with what you can do. Remember the extent of this ruling and what the law still permits you to do. Don't let a minor restriction impede you in the performance of your duties." And again, this has been Eric Atstephanous, General Counsel for the Massachusetts Chiefs of Police Association. Thank you for listening. Have a great day and be safe.